The next case on this morning's docket is from Pawnee County. Case number 126966, State of Kansas appellee versus Justin W. Hammond appellant. Would the parties please state their appearances?
Good morning. I'm Jonathan Lawrence for appellant Justin Hammond.
Thank you.
May it please the court, the appellee, State of Kansas, appears by Stephen J. Obermeyer, Assistant Solicitor General.
Thank you. And would the appellant like any time for rebuttal?
Yes, Your Honor. If I may split 75.
5 are granted, and you may begin.
Thank you. Morning, Your Honors. As an introduction, Mr. Hammond owned a roofing company with his wife, and at one point they took in a 14-year-old young woman in the community who was having some family issues. She was their babysitter and then became an office worker in the roofing company. And unfortunately, Mr. Hammond and her became very close. Their relationship developed. They came out to their families about the relationship after the girl's 16th birthday. And shortly thereafter, her family persuaded her. Initially, she said that the relationship began after her 16th birthday, and then she changed the story and said it started when she was 14. That was the testimony at trial. Mr. Hammond testified. The jury convicted. Mr. Hammond was convicted of 5 sex offense charges. The jury acquitted him of 4 others. And he was ultimately sentenced to 96 months. There are 3 issues on appeal, but the primary one is this. After the third day of trial, that evening, one of the jurors called the Larned chief of police. Initially, earlier in the evening, she had a police incident at her home with her daughter, teenage daughter. I think the daughter was 16. But then she called the chief of police later and said, listen, I've got problems with this kid. I don't want to go to court tomorrow. I don't want to be on the jury. I want to get her some help. And the chief said, ma'am, you're calling the wrong guy. I can't tell you you can't be on, you don't have to go to court tomorrow. The chief of police then called the prosecutor. Would have been better if he called the judge, but he called the prosecutor. And the prosecutor told the chief of police, hey, call her back, tell her she doesn't need to come tomorrow. I'll take care of it.
But actually, didn't the prosecutor say, I'll inform the court? I mean, the prosecutor didn't, and the police officer even testified, the prosecutor didn't tell me that I could tell this juror she was excused. She said, you can stay with your daughter and I'll inform the court basically of the situation and let the court decide. You can stay home. I'll tell the court what's going on, and then the court can tell us how to proceed from here. And then the judge basically said at the hearing, please tell me, give me any information that would indicate I would have proceeded differently, why I wouldn't have excused this juror based on that situation.
Your Honor, my understanding is the information given to the juror was through the police chief of police, tell her she can stay home. The rest of it, I do not believe was told to her, that I'll talk to the judge and we'll see if you have to come back.
The prosecutor testified, and I said, I just have her stay with her daughter and I'll inform the court this morning.
Right.
Of the situation. And the police officer testified that no, the prosecutor didn't say that she was excused. Did the prosecutor tell you that given the circumstances she was excused? And the police officer said no.
I don't think there's any.
No, he was going to contact the court this morning.
I don't think there's any meaningful difference between telling somebody to stay home and actually using the word excuse. So, as the judge said, when he found out, the judge said, under what black letter law did you think you could do that? So I don't think there was any confusion that this prosecutor put on the robe and tried to slip into the shoes of a judge and came up woefully short in the toe and said, tell her she can stay at home.
Counsel, but isn't that why you have a motion for a mistrial and the judge can take that into consideration? And the judge here came to the conclusion that there wouldn't have been any other separate, different action that was taken. It was unfortunate the manner that it was taken. And it was the prosecutor overstepping his bounds or their bounds with regard to that action. But the ultimate outcome, that is, juror is excused and alternate juror is impaneled, is the same.
Well, Judge, here's where it matters. Standards matter. The law matters. The law applicable to situations matter. And here's what's important to remember. That prosecutor, and it's on pages 18 and 19 of the state's brief, and it's volume 8 in the record, pages, I believe it's pages 9 and 10. If not, it's 10 and 11. But here's what happened. The prosecutor says to the judge, yeah, it's at pages 9 and 10 of volume 8. My conversations were solely with Chief Orth and said, well, just tell her to stay home. Tell her to stay there. I don't think we've reached the point that she's been officially discharged. Your Honor, I recognize the error in that moment, that I should have just said, you've called the wrong person. You need to call the court in that situation. So what do we have there? The state now is claiming that it wasn't prosecutorial error. So standards matter. The prosecutor admitted to the judge that morning, I committed an error. We used to call it prosecutorial misconduct, but it's prosecutorial error for 3 reasons. It violated a statute, 22-3340, right?
But counsel, but before you go through that, and I think that the prosecutor agreed that there was an error.
Prosecutorial error.
So the question on appeal is, how do we review that, right? Is it a question of pure prosecutorial error? And usually when we review questions of prosecutorial error, they haven't been brought up before the district court before. There hasn't been an opportunity for the district court to weigh in. It's brought up for the first time on appeal. Sure. Here, it was brought up to the district court by way of a motion for a mistrial and then by way of the motion for a new trial. Right. And in both of those instances, the district court, which in that court's infinite wisdom knew how it would rule in those circumstances, said that the outcome would not have been different, and thus denied the motion for a mistrial and denied the motion for a new trial, which we review for an abuse of discretion.
Judge, with all due respect, you're leaving out the most important part. You're correct about what he said at the motion for the mistrial, but that's not correct with regard to what he said at the motion for new trial. What the judge said then is, and I'm paraphrasing, I've been thinking about this. You know what? You're right. There's no way we'll ever know what the prejudice was. We don't know what that juror would have done. Okay? The reason these standards matter, and you know something that's, you stated very eloquently, Your Honor. These situations usually arise for the first time on appeal. This was fully argued, then it was fully briefed, and there's no, I'm not ashamed to say it. I cut and pasted liberally from Mr. McConnell's motion for new trial. The state says I'm raising this for the first time on appeal. You can compare the motion for new trial and my brief. I relied on the same exact 7 cases. The standard matters. If they're
You're talking about the court saying they don't know what the juror would have done, and we're talking about we know what the judge would have done, because
Sure.
The judge consistently said, if I was presented with those facts, that's ultimately what was going to happen in any event.
You cannot.
I understand procedurally we've got an error, but at the end of the day, the court was going to say, yeah, she's not going to pay attention to trial today. She's obviously going to be concerned with her daughter. So she can stay home.
Rhetorically speaking, does procedure not matter? I mean, let's be serious here. This is the usurpation of judicial function.
But we look all the time at prosecutorial error, and it's 2 steps. Yeah, we agree. First, we look and find that there's an error, and here the prosecutor admitted it was an error. I don't think that's the question. But then we look at, okay, people make mistakes. What's the consequence of that mistake? And does the consequence prejudice your client? And that's at least what I'm struggling with is, regardless of the error part, how does it prejudice your client if the court was going to do the same thing?
And my response is this: it was never Mr. McConnell's and Mr. Hammond's burden to show how they were prejudiced. Under the prosecutorial error standard, the burden is solely on the state.
How did the state not meet that burden by the court saying I would have done the same thing?
The state made no attempt to show that it was a harmless error. And in United States versus Remmer, the U.S. Supreme Court's weighed in on this. The U.S. Supreme Court, I'd like to read the quote so I don't get it wrong. This, I mean, it's in a criminal case, any private communication, contact, or tampering directly or indirectly with the juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial.
But the prosecutor didn't have direct contact with the juror.
Directly or indirectly. This was definitely indirect contact.
And would you read that quote again? I thought that I heard you say, with regard to the matter at issue at trial.
With a juror during a trial about the matter pending before the jury, right? Her jury service, you had the statute prohibiting the conduct, you had the disciplinary rule prohibiting the conduct, and you had the judge tell the jury, and for the benefit of the lawyers, it's a pick. It's a standard jury instruction in this state. There's to be no contact. If you have a problem with your jury service, you don't go to the lawyer, you go to the bailiff. Now, the reason these things matter, let's look at this. If in every case we just simply brushed aside any error because a district court judge chose to just fix it by saying, I would have done it anyway. As I said in my brief, today we're going to be here on a prosecutor sending a juror home. Tomorrow we're going to be here on a prosecutor signing a search warrant. If the district court judge says at the suppression hearing, you know what, I was going to sign it anyway. I mean, that's just not the way the rules are supposed to work. I don't think that there would be any dispute that if I had sent the juror home, or if Mr. McConnell sent the juror home, would be here on a far different matter. It wouldn't be in front of this court. It'd be in front of the Supreme Court. You can't tell a juror to stay home. The appearance of this is just outrageous to reasonable people. The state contended that this was reasonable. And I want to urge you, here's what's reasonable. Let's talk about what's reasonable. Telling her to stay home wasn't reasonable. You know what was reasonable? Call the judge. You know what else would have been reasonable? Wait for the morning, bring the juror in. You know what? She got a problem with her daughter? Tell her to bring her daughter in. We'll sit her daughter in the clerk's office. You know what else was reasonable? And I'd like you to take judicial notice of this. There's an exchange in the transcript of that hearing. And this is from March 9, 2023. This is page 21. I don't know, and I won't say her last name, all right? I don't know Mrs. M's family situation. The father is in the home as well? The answer, he had gone to work. He's in the National Guard full-time, and his unit is in Dodge, so he was not in town. That's a little bit liberal stretch of how we're talking about.
So I want you to just to be aware that you're eating into your rebuttal time. So
Okay, I will wrap up. It's 61 miles between Dodge City and Larned. What should have been done is, hey, tell him to tell his commander, if he's not a commander, he's got a problem with his daughter. Either bring the daughter to court or have the dad step in. But the state had no right to tell her to stay home. Thank you.
thank you, counsel. Mr. Obermeyer?
Thank you. May it please the court, the state appears by Stephen Obermeyer. As the court just heard, this case is about the procedure of what happens when life happens and gets in the way of a juror in jury duty, and how to address it, and do we put form over substance. And here, life happened on the evening of the third day of jury trial, when about 9 to 9:30, the juror, actually potential juror, because there were 14 jurors selected and nobody knew who was going to be an alternate until, I guess, after closing arguments. But anyway, the potential juror has a 16-year-old daughter, is having a schizophrenic episode, threatens to kill herself. There's a knife involved. She is taken into police custody, protective custody, and screened. She was pending admission into a treatment facility. It was an all-night thing. And at 7 the next morning, the chief called the prosecutor and said that the mother was going to have to be one-on-one with her daughter, and that they had made private arrangements for transport to Newton. And from Larned to Newton, I think, is about 100 miles. And that she had been up all night and was basically an emotional basket case. And the father was in Dodge City in the National Guard. And so the question is, what do you do? Do you bring the juror in, and the prosecutor, we contend, did not unilaterally dismiss the juror. He told the chief he would contact the court, and most probably she would be excused, but stay with the daughter. He would contact the court in the morning. And so that happened. The morning came. Initially, defense counsel was very sympathetic to the juror's plight and said, I leave it to the discretion of the court. And then after a 17-minute break, defense counsel moves for a mistrial. And the arguments made relate to a mistrial and not prosecutorial misconduct. The mistrial statute, KSA 223423, states that if there is prejudicial conduct in or outside the courtroom that makes it impossible to proceed with the trial without injustice to either the defendant or the prosecution, then a mistrial. The judge has the discretion to declare a mistrial.
Counsel, I was going to ask, what standard do we apply on appeal? What is the issue that's before us? Is it a prosecutorial error issue? Is it a mistrial issue? Because those are different standards.
Correct. The state's argument is that the traditional denial of a motion for mistrial standard should be the standard. All of the prosecutorial misconduct cases, starting with Sherman, involve actions in the courtroom, as far as I think. Closing argument, opening argument, things like that. And here, certainly the state, if the error is the 16-year-old having a schizophrenic episode, the state had nothing to do with that. But if the error is saying, I will inform the court, stay there, she will likely be excused, then we're looking at that.
In your research, did you come across other examples of instances where an attorney or a prosecutor has taken some out-of-court action and the court has reviewed that? I've had a hard time coming up with something like this, and it may be because, as your opposing counsel has said, that this is kind of out of the blue. This just doesn't happen.
I would agree with that. My colleague and I, neither of us could find a case on point anywhere on this issue. I would think, and I didn't look like, what if there's a case where a juror on one of the nights of trial gets arrested or, can't make it? How do we proceed with that? But here, the juror clearly was not, she could have been summoned to court. The court had her telephone number. She was eventually dismissed by the court. So somebody had to let her know that she didn't have to come out. And so when the defendant is arguing at the trial level that there's a mistrial, why is it impossible to proceed? Defense counsel says that even if Judge Gatterman, who was the trial judge, telephoned TM and told her to be in court today, realistically, she's going to blame me, defense counsel, for forcing her to be here. I disagree with that contention. I think Judge Gatterman, in his 20-some years of experience, could wordsmith some instruction to the juror to say, we need to have you here, and maybe bring her daughter as well. I don't know, but that could have been wordsmith. The potential juror is not going to think this is all on the defense. So I think that argument for impossible to proceed fails in that situation. And then again, as to dismissing TM under the facts, defense counsel said, I understand the situation. I'm very sympathetic with the situation for her daughter. I leave that to the court's discretion and thoughts, and I'm happy to answer questions. That's at volume 8, page 5. So she was going to get dismissed anyway. Defense counsel left it up to the court's discretion as far as whether she should be dismissed. As to the defendant's argument that Judge Gatterman improperly shifted the burden to the defense to demonstrate error, I think defense counsel even thought that on a motion for mistrial, it's the defendant's burden. And the reason for that, if you look at page 16 of volume 8, they summon the police chief, and the prosecutor starts to question the police chief as far as what had happened. And defense counsel says, Your Honor, I think given the circumstances, it would probably be more appropriate if I asked the questions of the witness. So clearly defense counsel thought it was his burden to show that there was substantial prejudice with the mistrial. And when the court asked defense counsel at page 10 of volume 8, what's the prejudice? He doesn't say it's not my burden, it's the state's burden. He gives his arguments that I discussed earlier about the jurors going to think it was my fault for being here.
Counsel, and that's why I ask about the appropriate standard, because in most mistrial situations where there's been a motion for a mistrial, there hasn't necessarily been some gross misstep by the prosecutor. There hasn't been an error. Whereas here we have a prosecutorial error, and usually that means that we use the constitutional harmless error standard, which is different from our mistrial standard. And so I'm just trying to figure out how these mesh. If you were to put yourself in a position where, say, at some point you had to write an opinion, how would that opinion write?
I would look at the unpublished case that my colleague cited, where the prosecutor talked to some potential jurors during a break in the case, and the Court of Appeals analyzed that under a denial of a motion for mistrial abuse of discretion standard. And if you look at the Sherman, I mean, the template doesn't seem to fit with what happened here. But even if it did, I would say the fact that the judge, having heard all the facts, the judge was formally excused a juror, was going to excuse a juror based on that she was an emotional basket case, been up all night. She was in no condition to be a juror. The judge said, based on the chief's sworn testimony, principally the trauma within the home, the mental health of the juror's daughter, the fact the juror has been basically up in that situation all night long and still has issues to attend to as far as going to Newton, the court presented with those facts would have excused her. And so I think the fact that we should not look at form over substance in this case, and the mistrial standard of review should be the one that applies. But if not, I think under a harmless error standard, that certainly the judge would have done the same thing. And I don't know if you have to look at the evidence supporting the conviction. Our arguments have nothing to do with the evidence at trial. But if you look at the 5 counts that the jury found Mr. Hammond guilty of, all of them involved a photograph where she testified about, this is the day of the snowballs, where we had sex that day before I turned 16. And this is my birthday when I turned 15, and I had a golf tournament that day, and he molested me. All the counts they found guilty on involved pictures of her that were introduced in talking about that. I will just wrap up and say, as Judge Gatterman said in the motion for new trial at volume 12, page 5, the excusal of that juror had no bearing upon the manner of presentation of evidence or the evidence that was presented. And none of those jurors knew whether or not they were an alternate And the court did not find any substantial prejudice as a matter of law through the excusal of the juror. And there was no showing of a reasonable probability the result of the trial would have been different had the juror not been excused. Unless the court has any questions, for those reasons, the state would ask that you affirm the defendant's convictions.
All right, thank you, counsel. So you have 5 minutes.
Thank you.
There's been some mention about, hey, let's think about what was really going on in the moment. All right. There's no doubt that this was sprung on Mr. McConnell, and Mr. McConnell operated under the motion for new trial standard. But Mr. McConnell did something that most lawyers wouldn't have done after the dust had settled, because you got to remember something. He wasn't told before court that day. He wasn't called that night. He walks in. He's trying a case. Oh, yeah, there's been a juror dismissed. Or judge, there's a juror not here. He's flat-footed, but you know what he did? As an excellent practitioner, he went and researched, he found the correct standard, and he filed a motion for new trial. He gave the state and the court the opportunity to apply the right standard. Right? There's no issue about preservation. The state originally raised it. They didn't raise it. They didn't carry through with it today. This is a properly preserved issue under the correct standard. I didn't change the standard, right? So if I had come in here, because prosecutorial misconduct generally arises for the first time on appeal, and I write this brief about prosecutorial misconduct and how the district court didn't apply the right standard, right? Maybe then you'd say, well, why wasn't this raised below? This actually was raised below, and the judge said, things might have turned out differently. But we almost had a case. And Judge Coble and Judge Klein, if you'll think back for a second, last July, you all issued an unpublished opinion, and it was State versus Mills. You know what happened there? Overnight, from the fourth day of trial, before the closing arguments, maybe you all will remember this, the lawyers walk in and the judge says, I sent 2 jurors home last night. I sent them home. The judge, I sent 2 jurors home last night. This place always is cursed. One juror got COVID, the other juror's house burnt down. That's how it's supposed to happen. Justin Hammond is entitled to that procedure being followed. Otherwise, you open the door. And if you say, well, if a lawyer just happens to hear about a juror with a problem, the lawyer, what happens in a PI case? If I'm a really smooth talking personal injury lawyer, I go out in the hallway. Maybe I'm out at the restaurant on the second day of trial having lunch, and I see Mrs. Jones, and I'm not going to talk to her about the case, but she said this is a burden on daycare, and Mr. Smith said it's a burden for him to be off work. And I just asked them how their jobs are doing or how's their kids. And then they say, oh, this is just onerous. I just can't be there. Hey, you know what? It's okay. Go home, be with your kid, go back to work, tell your boss, you'll be there. I'll tell the judge, because that's what this opens the door to. This is wrong. I mean, it's like, I feel like I'm screaming from, a valley. Like, how could any of us in law school hearing this think that this is okay? That a lawyer told a juror, stay home. It's just not right. And under the standard, the correct standard that was offered up to the district court before the motion for new trial, the district court could have said, you know what, you're right. The prosecutor admitted on day one that it was an error. We've got to apply the correct error. Let's fix this, or correct standard. Let's fix this error, and let's give the state the opportunity to make the record. The state didn't want to make the record. So the remedy here is for a new trial for Mr. Hammond. Thank you.
Thank you very much. And thanks to both sides for your excellent briefing and for your oral arguments. We'll take the matter under advisement.